Welcome everyone. Thank you for joining our webinar today. We are going to talk about the formal EEO process. Just a little background about myself. My name is Derrick Hogan. I'm a partner here with Tully Rinckey. I focus primarily on federal labor and employment law, private employment law, as well as criminal defense. I've handled multiple matters, various matters within the federal sector, whether it be EEO, MSPB, complaints with OIG or Office of Special Counsel. So well-versed in these matters, and I hope to provide you guys some valuable guidance today regarding the formal EEO process. Okay, so a couple things you're going to learn today. One, when can you file a formal complaint? And kind of piggybacking off of that, what to include in the formal complaint. When you file formal complaints or any kind of EEO complaint, there is a timeline process that needs to be followed, and it's a very strict timeline process because if you do not meet those deadlines, it could potentially jeopardize your EEO complaint. So one of the things I will stress today is the importance of these timelines and the need to submit any documentation, responses, things of the like by those deadlines. We'll also talk about a report of investigation. A report of investigation is a document that you would get after you file your formal complaint and the investigative stage ends. We will also talk about the choice between an EEOC hearing or a final agency decision, because after you receive the report of investigation, you're going to have one of two options. You're going to be able to request an EEOC hearing, or you're going to be able to request a final agency decision. So we'll talk about both of those options. And then lastly, we'll also talk about your appellate rights. Should your case get dismissed or you receive an unfavorable outcome, you do have appellate rights, and we can talk about that as well today. Okay, first things first. Just a little bit of background. When you get to the formal stage, that means you've already completed the informal stage. And the informal stage is usually a 90-day period. It may be extended, where you meet with an EEO counselor, you try to engage in a resolution of the matter. You don't have to participate in ADR, which is alternative dispute resolution, but in that informal process, you do have the option of either participating in ADR or mediation. If you are unsuccessful in that process, and you do move forward, and you are now at the formal stage of your complaint. And it's very important because when the informal stage ends, if you will, you're going to receive what's called a notice of a right to file a formal complaint. And that document is very important. And if any of you have a current complaint and you've received that, you'll know, but it's a very important document because there's a timeline issue in connection with receiving that document. So once you do get into the formal stage, if you will, a couple things you would want to consider. If, sometimes these things get overwhelming and you've never been through the process before, so that's why it's important that you might want to consider retaining counsel to kind of guide you through this process. I kind of mentioned there's quick turnaround, so you definitely want to pay attention to deadlines because, and I'll say this throughout the webinar today, if you miss those deadlines, it's going to be potentially detrimental to your case. So very important to be cognizant of those deadlines. And then also the formal gets you to start thinking about things you're going to be discussing with an investigator, because once you file the formal complaint, you're going to be asked specific questions from the investigator. So maybe a good time to get your thoughts in order, get you a timeline of the events that you feel are pertinent to your claim. Okay, so we talked about notice of a right to file a formal complaint. So after the informal stage is done, you will receive the notice of a right to file a formal complaint. It's very important that you file your complaint within 15 days of receiving the written notice of a right to file a formal complaint. Now, a couple things with those deadlines. If you already have counsel, it is technically 15 days from when your counsel receives the notice of right to file. That could be the same date it's received by you. In other instances, if the document is, say, mailed to you and it's dated, say, April 13th, but you don't get it in the mail till April 15th, it should be from the date you receive the document. So, and I know a lot of times, sometimes agencies might email the document to you. So it's very important to note the date you receive that documentation, and then you calculate your 15-day deadline from that. What's also important to note is that with the 15-day deadline, if that 15th day falls on a weekend or a holiday, then you do have the next business day to file. So for example, if your 15-day deadline falls on a Saturday or Sunday, you would have, your deadline would be the following business day, Monday, to file that formal complaint. Unless let's talk about the information you're putting in your formal complaint. Unless you're filing an amendment, or maybe, which would be, say, a new event that's happened since you filed your informal complaint, you kind of want to include the claims, the same claims that you included in your informal complaint. Like I said, if you filed your informal complaint and subsequently there was new information, or there was a new discriminatory act, then you do have the ability to amend your claim. But usually with your formal complaint, you're just going to transition the same claims you had in your informal complaint into your formal complaint. Specifically, you need to include, what happened and why it happened. You don't have to get too deep into why you feel it was discriminatory, or why you feel they violated certain rights, or why it was, say, a harassment or a hostile work environment. But you do have to have some specificity as to the event that took place, why you felt it was discriminatory, and maybe as much as you can, the date the event happened. Okay, once you do that, you'll file your formal complaint. The agency will then send you acknowledgement letter, and the acknowledgement letter will state whether or not they're accepting your claims or not. Sometimes they respond back with an acknowledgement and they say, we're going to accept all your claims for investigation. So if you included, say, 5 claims, 1, 2, 3, 4, 5, or A, B, C, D, E, the agency will say they have accepted those claims for investigation. Sometimes they may dismiss your claims. One of the reasons that they might dismiss it is they say it's out of the 45-day time frame. So, for example, if you filed your initial EEO claim on, say, April 1st, but one of your, and I'm talking about in the informal stage, but one of your claims deals with something from, April 2020, the agency might attempt to dismiss that claim because it's outside the 45-day window for someone to report, a discriminatory act. So the agency might dismiss some claims. If they do, you will be provided an opportunity to respond to any of those dismissals, or if they do not accept it for any other reason. They might say it's not an actionable claim, or they might say it's not, the claim doesn't have enough specificity to it. You will have the opportunity to clarify those claims or file a response to the dismissal prior to any investigative stage. Okay, so let's just say that you've received correspondence from the agency. They have acknowledged your claim. They've accepted your claims for investigation. So now what's next? You'll be contacted by an investigator. And an investigator is usually an independent third party that's contracted by the government to investigate your claims. The investigator is not affiliated with the agency. They're not an employee with the agency. They're usually third parties that provide these quote-unquote investigative services. And usually the initial contact from the investigator is they reach out to the agency and request certain documentation from the agency, whether that be policies, procedures. Sometimes they look for the composition of the staff at the agency or the particular department, because if you have a claim of discrimination based on race, sex, age, they want to look at the composition of the employees that you work with. We call them comparator employees, as well as the chains of commands and your supervisors. So the agency is required to provide that documentation to the investigator. Now, at some point, the investigator is going to reach out to you, the complainant, or your counsel, if you are represented by counsel, and they're going to set up a time to interview you. I've seen it go both ways. The investigators do it one of two ways. They will provide you an affidavit, a document, an affidavit form with specific questions. And those specific questions relate to your claims that you've outlined in your formal complaint. And what you are required to do is provide a written response to those questions. Another avenue that the investigators sometimes do is they do, say, a telephonic interview where they interview you, they ask you questions, and they transcribe the interview. And once the interview's done, they will provide you a transcript, not immediately, but in due time, they'll provide you a transcript of your interview, and you'll have the opportunity to correct anything, amend any of your answers, or just basically say, I didn't say this, I said this. The point of all that is, and here's where it's very good idea to retain counsel, is because sometimes these affidavits can be overly burdensome for an individual, especially if that individual's never been through the process before. And there is, especially if you have a complaint with multiple claims and multiple incidents, they're going to ask you about every incident. And if you allege multiple bases, say, I was discriminated based on race, sex, age, and retaliation, they're going to ask you specific questions related to why you felt it was the agency's actions were discriminatory based on each of those individual bases, whether it be race, sex, age, religion. I'm just throwing examples out there, but they're going to hit home every claim and every basis. So just as like a practical matter, I prefer when the investigators send written affidavits, because that way I can work with my clients and we can kind of frame the narrative. We can frame the questions how we want, not the questions, the answers, how we want to. It's a little different when they're saying interviewing you telephonically and you kind of have to provide an answer off the cuff. And not to say there's anything wrong with that, because you do have the opportunity to correct that information down the road, but it's a lot easier when you have the ability to control your own questions. And quite frankly, if you have a representative, you can have your attorney look at those answers. And I usually work with my clients on, framing our responses to make it sound as best for your case as possible. And these are important because these affidavits that the investigator gets from you are going to be a part of the report of investigation. And that report of investigation is going to follow you whether you request a final agency decision or ultimately if you go to an EEOC hearing. So it's very important. You want to kind of hammer home your responses in the affidavit, because that is one of your bites at the apple, if you will. It's not your only bite at the apple, but that's kind of to give a first impression of why you think you were discriminated against and what the basis was and how the agency's actions affected you. So the affidavits are very important. Another aspect of that is the investigator might require some documentation, and that's any documents you feel are related to your claim. Hey, I got an email from my supervisor that's harassing, or you have a certain memo you receive from your supervisor that is directly related to your claim. That'll give you an opportunity to provide that information to the investigator. Another aspect of the investigation is the investigator will reach out to, we call the RMOs, or the responsible management officials. And these are the individuals that you include in your claims that you feel are discriminating against you. And they might reach out to potential witnesses. But specifically with the RMOs or anybody you feel that has discriminated against you, the investigator will provide them the same thing, an affidavit, or they'll telephonically interview them, and they'll essentially ask for their take on the situation. And the RMOs or the supervisors, they will provide their responses. You have the opportunity to rebut those responses. So once the investigator gets all the information from the the RMOs and the other supervisors, they will provide you, the complainant, with that document, and that'll be your opportunity to rebut any of the things they say. You know, in their affidavit, they may say ABC happened, and you can provide a rebuttal to say, no, that didn't happen, XYZ happened, and here's my documentation to back it up. So in rebuttal affidavits, they're not necessary. They're not essentially required by the complainant to submit one. But if it's something that after reading the affidavits you want to provide a rebuttal to, you certainly have the right to, and the investigator will provide you the opportunity to do that. And once again, just like I mentioned with our affidavits as a complainant, if you have an attorney, the attorney can kind of properly advise you and help you shape your rebuttal affidavit. And once all this information is put together, the investigator will issue what's called a report of investigation, or an ROI. And that's going to, you know, a lot of times investigators kind of put a summary of your claims, but there should be all documentation in that ROI from the beginning of your informal complaint process to any documentation you submitted in connection with your formal complaint. And usually with we call it the investigative period, it's usually 180 days. You do have the opportunity to extend that period. Sometimes if we need a little bit more time to provide an affidavit, we'll request an extension from the investigator. But in a general sense, there are opportunities to get an extension. But in a general sense, the investigation is going to last 180 days. And then once the investigation's over, the investigator will issue the ROI, or report of investigation. Okay, so now you have your report of investigation. What do you do with it? This is important because, once again, here's another very strict deadline, okay? Once you receive a report of investigation, or if you're represented by counsel, once your counsel receives the report of investigation, you have 30 days from receipt to make an election, okay? And once again, the same guideline applies. If you receive the report of investigation and your 30th day falls on a weekend or a holiday, you have until the next business day to file your certain request. I'm of the opinion, just to be safe, if my 30th day falls on a Saturday or Sunday, I'll try to make sure I submit something by that previous Friday, just in case we don't miss any deadlines. But you do have the next business day if your deadline falls on a weekend. So what do we do when we receive the report of investigation? Well, you have two avenues. One is to elect an EEOC hearing, and we can get into that. And the other is elect a final agency decision, or what we call a FAD, F-A-D. So let's talk about both of those. Number one, with the final agency decision, you have to notify the agency within 30 days of receiving the ROI if you want a final agency decision. If you don't request anything, whether it be an EEOC hearing or a final agency decision within 30 days, then the agency will automatically, your claim won't be dismissed, but then the agency will automatically issue a final agency decision. Not right away, but if you don't make any elections within that 30 days, you will get a decision on your matter. So what does the final agency decision entail? That is essentially a member of the agency, not any of the people you named in your complaint, but it is personnel with the agency. They will review the report of investigation. They will review all the affidavits, basically all the evidence included in the report of investigation. But it's important that that's all that they're really going to base their decision on. There's no other documentation that they're going to base their decision on. And we'll get into, with the EEOC process, how you can get further documentation in connection with your matter. But for the final agency decision, they will make a decision solely based on the report of investigation. And they will provide you with that investigation. I believe they have 40 days after you either elect or to receive a final agency decision, or after you decline any option to issue that decision. And that decision will contain an analysis of whether you have satisfied the burdens of your claim, and they'll make a decision as to whether the agency did discriminate against you. Now, I caution people regarding final agency decisions, because the way I look at it, and other people might have a different opinion, but the way I look at it is, if you elect a final agency decision, you are essentially asking an agency official to determine that another agency employee discriminated against you. And I think sometimes, not that agency officials are doing anything improper or that they would not follow what they're supposed to follow, but I just don't feel that that is the best course of action for an agency employee to determine if the agency discriminated against you as the complainant. But that is one avenue you can take. The other avenue is you can request an EEOC hearing before an administrative judge. Now, this is important because it has to be done within 30 days. If you miss that 30-day deadline, unless you have some justifiable good cause, you lose your right to go to the EEOC for a hearing with an administrative judge. So once again, the deadline is very important. And I could talk a little bit about the EEOC hearing process. Once you file a request for hearing, you will be assigned an administrative judge. Now, I can't put a guarantee on the timeline for the process, but sometimes it takes some time. Sometimes it takes a couple months. Sometimes it takes more than a couple months. But eventually, an EEOC hearing, an administrative judge will be assigned to your matter. And that's different from the final agency decision, because now the EEOC judge is an independent third party. They are not an employee of the agency, and they're not necessarily, on your side, if you will, as the complainant. They are an independent third party. But kind of like I was saying earlier, now you have a judge that knows the processes, knows the procedures, and that they can decide one way or the other whether you have a sufficient claim for discrimination. I also mentioned, when talking about the final agency decisions, that when you get the report of investigation, that's all the final agency decision is based on, is the report of investigation. However, if you engage in an EEOC hearing process, you have multiple opportunities to get more information, more testimony from individuals. And how is that? One is you engage in discovery. And this is in the hearing process. And discovery consists of a couple things: interrogatories, which are written questions, requests for document production, and also RFAs, requests for admissions, where essentially a statement is made and you admit or deny that statement. And the reason I say that, once again, is because if everything's not in the report of investigation, this gives you another bite at the apple to obtain specific information from the agency, for you to obtain more documentation from the agency, for you to get them to provide you more information in connection with requests for admissions. It is reciprocal as well, meaning the agency can serve you with discovery demands as well. So then you have to respond to their interrogatories, respond to their production requests, and respond to their request for admissions. But it does give you the opportunity to engage in a more thorough process for you to get more documentation in connection with your claim. Once again, especially if you're at the hearing process, this is where you probably want to get an attorney, if you haven't already, because it can be complicated, especially with the discovery request. Another thing that you would get through the hearing process is you can engage in depositions. You have the ability to depose agency employees, agency officials, and conversely, they have an opportunity to depose you or your witnesses. So that's where it's very important to have an attorney, because if you've never been through a deposition, you might be timid, you might be scared. It's an unfamiliar process. You have an attorney on your side that knows what questions to ask and can guide you and prep you when you have to answer those questions. So those are very important things. Discovery and depositions are an important part of the hearing process that that you don't get with final agency decisions. As we move along in the hearing process, once discovery is concluded, I should also mention that throughout the hearing process, there's going to be what they call ISCs, initial status conferences, or status conference settlement conferences. At every point during the hearing stage, a judge is going to ask, have the parties discuss settlement. And in fact, a lot of judges require settlement updates in their orders, where you and the agency have to file a joint report as to the status of settlement. Now, settlement takes two to tango, meaning both you and the agency have to want to engage in settlement discussions. Although not required, a judge is going to encourage that because, number one, it takes cases off their docket. And number two, if you don't want to go through a hearing process, and I know a lot of these things probably cause you guys, some grief, some stress, maybe even some anger, if you can reach an amicable settlement, that can alleviate any of those concerns. So at every point in the process, the judge is going to reach out, see if the parties have engaged in settlement and what is the status of those settlement discussions. I will point out, though, that you do not have to settle anything, nor does the agency. It's just something that's going to be brought up along the way all the time. But if you don't resolve your matter, you engage in discovery, at some point you're going to get a hearing. And it's a regular hearing, just like a kind of everyday court procedure. It's not necessarily what you think you see on TV, but it's a hearing with witnesses, arguments, exhibits, documentation. All those things will be presented. You'll have the opportunity to testify on your own behalf. You'll have an opportunity to present witnesses on your behalf. And conversely, you'll have the opportunity to cross-examine any agency witnesses. So once again, if you're at a hearing stage, that's when you really want counsel, someone who's well-versed in the aspects of this, not just, say, EEOC claims, but general court demeanor, general court etiquette in hearing processes, because it can be intimidating. I've been doing this 13, 14 years. I still get a little nervous, walking into a courtroom or walking into a hearing, and that's just human nature. So if I do it as an attorney, I can imagine as an unrepresented complainant, the nervousness or stress you might have as a result. So something you definitely want to have if you go to a hearing stage. But once you complete the hearing, the judge will ultimately make a decision on your matter, and they'll order relief if they feel discrimination, if your claims are substantiated. Sometimes the judges will bifurcate the hearings. And what do I mean by that? Bifurcate, split the hearings. One hearing might be on liability, meaning did the agency discriminate against you based on the claims you've raised? And the other part of the hearing might be on damages. So it might be, okay, we have found your claims to be substantiated. Now, how are your damages? Because sometimes you can't just throw out a number. Oh, I want X amount of dollars in damages. You're going to have to prove and show some type of documentation of how you got to that number. So, for example, I tell this clients all this time, the maximum compensatory damages that an EEOC judge can award you is $300,000. And a client says, well, I want $300,000 then. Well, you're going to have to justify that. You can't just pull a number out of thin air. You're going to have to justify that number to a certain extent. So it's something to be cognizant of. But once again, the judge will issue a final decision. And then once that judge does issue a final decision, if it is a negative decision, you do have the ability to file an appeal with OFO, the Office of Federal Operations. And I should also add that whether it's a hearing decision or going all the way back to the final agency decision, if you elected a final agency decision, if the final agency decision is not agreeable to you, you also have the opportunity to file an appeal with OFO. So you do have appellate rights, whether it's with a final agency decision or a hearing. If you get an unfavorable decision, you do have the right to file an appeal of that. Okay, we kind of just touched on this, but after the AJ issues a decision, you have 30 days to file an appeal with the OFO. Normally, it's 30 days to file just an appeal. Basically, let OFO know you're going to appeal, and then usually once OFO acknowledges your appeal, you have 30 days to file your brief in connection with that appeal. Sometimes the OFO does grant extensions, whereas you need more than 30 days to file that appellate brief. And sometimes the judges do, or excuse me, OFO does, sometimes they don't. But it's important to note that you file your notice of appeal, and then you have 30 days to file your brief and statements in support of that appeal. And if you do file an appeal, the agency has the opportunity to file a response brief. So you'll submit your brief, you'll submit your statements in support of your appeal, and then the agency will file a response brief. And then once you do that, OFO will review all the documentation. It's a de novo review. They'll review everything associated with your case, and then they'll make a final decision regarding your appeal, either upholding the decision or reversing that decision. Now, I think it's also to note that, I've talked about this in connection with if you as the complainant receives a negative decision or an unfavorable decision. But I would advise you that sometimes, even if you prevail at a hearing or you as the complainant prevail with a final agency decision, then the agency also has an opportunity to file an appeal with OFO. And just kind of a ministerial matter, I know with OFO appeals, it does take some time for you to get a decision. I would say, just for example, and each case is different, but I filed an OFO appeal last summer, I want to say around July, and I'm still waiting for a decision on that in connection with that case. So it does take some time, but you will get some finality with it one way or the other. Okay. One other thing I want to talk about is you can always file your matters. You can opt out of the EEO process and bring a lawsuit in federal district court. And you'll see on your slides here the different times in which you can file a lawsuit in federal district court. It's after 180 days from the time you filed your formal complaint, if there's no final agency decision or there's no OFO appeal. If within 90 days, if you receive the agency's final agency decision and no OFO appeal. Within 90 days of receiving an OFO decision on your appeal. So it's important to note that you can go into federal district court, but I also caution people on that as well, because especially, if you're represented by counsel or if not. I mean, federal district court is a different bear, if you will. It's very more strict on procedure and policy. And that's not to say the EEOC is not, but the EEOC is an administrative tribunal, okay? Where you have, if you go to federal district court, you have federally appointed judges that handle all types of cases, from employment matters to civil litigation to criminal matters. So you really got to be on the ball if you choose to go to federal district court, because if you're pro se proceeding by yourself, they might give you a little leeway, but they're not going to give you as much leeway as they would if you were in the administrative process with the EEOC. And further, federal district court litigation, that's expensive litigation. So if you were to be represented by counsel, you need to be prepared to spend significant sums of money, because federal district court, it's more particular and more procedurally on point. So just some things to be aware of. But regardless, you do have an option to file or to move your case to federal district court. Okay. When should you engage an attorney? Well, I kind of talked about this, and maybe I'm biased because I'm an attorney, and I should say that, you should retain an attorney, even our firm, as soon as possible. But at the very least, you want to have at least a consult with the attorney, because it's been my experience, and I don't know anybody else on this call, but it's been my experience when I get a consult from an individual, a lot of times they say, I've never been through this process. I don't know what it entails. I'm completely lost, but I feel like I have some legitimate claims here. That's where it's important to get counsel involved, because we've been through that. We know the processes. We know the procedures. We know a lot of these agency counsel, and we have to deal with them on a daily basis. Now, I always tell people, just because I know an agency counsel doesn't guarantee a favorable result, but there's some familiarity with that. There's some familiarity there. and they'll be more inclined to deal with you. Maybe they'll be more inclined to settle with you if you have that collegial relationship with an agency counsel. Whereas if you're a pro se litigant, the agency counsel is going to deal with you, but they're not going to give you, let's be honest, I don't think they're going to give you the same professional courtesies as they might give me as an attorney or another attorney. And I just say that based on experience, because I'm telling you, agency counsel, they'll say, well, this person's pro se. I already got one leg up on him. I'm the attorney. That person doesn't know what they're talking about. So that's why I think it's very important to have representation during these processes. But also, if you don't want to retain an individual, at least have a consult with an attorney so they can, make sure you hit home certain points, make sure you are timely, and make sure that you're not wasting your time. For a perfect example, someone might want to file a claim, but they're way past their deadline. And it might not be the best news to give that individual, but I can at least advise them that they've missed a deadline before that person wastes any more time, energy, and aggravation trying to proceed forward with a claim that is untimely. And that's just one example, but certainly it's important to have an attorney throughout this process. But if not, at least consult with an attorney, prior to you proceeding on your own. Okay, so what kind of services do we provide here at Tully Rinckey? We provide all types of services in connection with federal employees. Specifically, we can help you from start to finish, whether that is at the beginning informal stage, all the way up and through a hearing stage. And it's important to note that you don't have to have counsel right away. Say you start an informal complaint, you can retain an attorney, you can retain our firm in the formal stage. You can retain an attorney at the hearing stage. While I recommend you kind of have an attorney specifically from our firm at the beginning of your complaint process, you can retain an attorney at any time. And we can help you at all stages, whether it's the informal stage, whether it's the formal stage in dealing with the investigators, whether it's through any settlement negotiations or mediations with agency counsel or judges. And then, of course, if you do elect an EEOC hearing, we can represent you throughout that hearing process. So very important to consider. We have a lot of attorneys, a lot of good attorneys here at Tully Rinckey that know the processes and procedures. They have relationships with agency counsels, and they'll be able to provide you the guidance and representation you need throughout these tough times. Okay. So we talked about initial consultations, and if you did schedule initial consultation, here's what I would look for as an attorney. Biggest thing here, and it talks about the description of the discriminatory acts, but the biggest thing I want to know as a consult attorney, number one, is where are you at in the process? Are you in the informal stage? Are you in the formal stage? Have you received an ROI? Have you elected a hearing? That is very important to me, because that way I can properly guide you through the processes and procedures. In addition to that, I'm going to want to know what took place, when it took place, how often, who was involved, and were there any witnesses? Specifically, who are the RMOs, responsible management officials? Do you have any coworkers that witnessed any of this? Do you know of any other employees say, hey, my supervisor made me do this, this, and this, but they didn't make this other white male employee do this? Like I said, we call comparator evidence. Do you have evidence of comparators where there are certain acts against you, but other individuals aren't subjected to that discriminatory activity? And dates and times are important too, because like I said, sometimes there's timeliness issues. So the big thing is, where are you at in the EEOC complaint process, and what are your discriminatory acts that you're alleging? And further, what are the bases that you're alleging discrimination? Is it race? Is it age? Is it sex? Is it sexual preference? Is it religion? Is it disability? Is it retaliation for engaging in prior protected activity, like prior EEO activity, or just raising general complaints? So those are all things to consider when speaking to an attorney during a consultation. Okay, so a couple things to remind you guys about. Discrimination It's not cool. It should never be tolerated, and nobody should be subjected to it. Unfortunately, it still happens in our day and age, and you want someone behind you that's fighting with you through the process. So regardless, you should always consult with an attorney. You might not retain an attorney, but you should always consult with an attorney. You want to be detailed. You want to be specific. I always tell clients, you can't just give me generalized information. Well, I think they discriminated against me. No, you might not have concrete proof, but I need something. You can't just say, well, because employee A, this happened to employee A, and this happened to me. I need more info, because ultimately you have to prove that. And that's not the easiest burden to prove. So you want to be as detailed as possible. You want to be as articulate as possible, and that's where an attorney can help you come into play. And the other thing, I don't want to beat a dead horse, but there's deadlines. If you miss deadlines, you are potentially negatively impacting your claim, meaning that you could lose your claim simply because you missed a deadline. So deadlines are important. And then also be prepared for a long battle. These cases don't resolve overnight. Sometime in cases of blatant acts of discrimination, that agencies will look to resolve these issues and settle these claims immediately. However, that's not always the case. And the acts of discrimination aren't as obvious and aren't as blatant as they may seem. So you got to be able to prepare to dig your heels in and be prepared for a long, drawn-out process in general, because some of these cases get backed up, but just there's a lot of stages to this, and you need to be prepared for that. Okay, so I know that prior to today, we had some questions. So I know we have some questions on the slide, so I'll address each one of those. And then if we have time left over, I know there might be some questions that have been chatted in, and we'll see if we can get to some of those too. So the first question is, who are the proper individuals to name in your formal complaint? That's a good question. Essentially, that is the individuals that you feel have discriminated against you, or individuals that knew of the discrimination against you. And I'm not talking about coworkers, witnesses. It's more along the lines of what we talked about, responsible management officials, RMOs. Your first line supervisor, maybe your second line supervisor. Or if it's because of a hostile work environment created, say, with a coworker, and you alert your first line supervisor of these issues, that's where another person that you can name in your complaint as a responsible management official. Because sometimes it might not be the supervisor that's directly discriminating against you. But if a supervisor has been made aware of discriminatory acts and nothing is being done about it, then you can include that individual in your complaint. But essentially, the people you want to name in your complaint are your RMOs, responsible management officials. That could be first line, second line supervisors. I mean, you can go even above that, but you're going to have to ultimately prove that had knowledge. A lot of these third line supervisors, they say, well, I don't even know that person, or I had nothing to do with whatever action they're alleging. So those are the individuals you want to name. Next question is, what happens when a claim is dismissed? And we kind of talked about that at the beginning. When you initially file your formal complaint and the agency sends back an acknowledgement of those claims, they might dismiss some claims. You have the ability to file a response to the dismissal of those claims. So you'll get a bite at the apple to explain your reasons why you think it cannot be dismissed. Now, if it's a timeliness issue, that's where you might run into some issues. If it's, once again, I use that 45-day example. If you're trying to claim something happened on April 14, 2020, and you're just initiating EEO contact today on April 14, 2021, you're very likely to have that claim dismissed because it's outside the time frame. But you do have an opportunity to respond to any dismissed claims. And then further, if the agency down the road in the hearing process attempts to dismiss some claims by filing a motion to dismiss those claims, you do have an opportunity to respond. But once again, if, say, a judge upholds the ruling of that dismissed claim, ultimately you still have the ability to appeal that down the road with OFO. Next question is, can you settle during the formal EEO process? You can absolutely settle during the formal EEO process. It just depends on the agency or you as the complainant is willing to do that as well. You know, I know a lot of times during the formal process we talk, it's like the investigative stage, right? Where the investigator's reaching out to you, they're reaching out to responsible management officials. You can always, you can always see if the agency wants to settle during this process. I just would caution you though, unless it's a blatant act of discrimination or acts of discrimination, they're going to be less inclined to settle that matter. They may, but I think less likely in the formal process. But as I also mentioned, as you move along in the process, even at the hearing stage, the judge, they're always going to look to settle these. They're always going to want to have a settlement conference. They're going to want to say, okay, what can these parties do to resolve this matter? Because I'll be quite frank with you, these judges have a lot of cases on their docket. These agency counsel, they have a lot of cases on their docket. They might be looking to settle, but you can settle during the formal process. Next question is, what happens in the event of a breach of a settlement? Okay, well, if you do settle your matter, you should have a written settlement agreement. And in that written settlement agreement, there should be an enforcement provision, meaning that you have a right to enforce this agreement in the event of a breach, and you can bring it back to the EEOC. Because a lot of times if you settle, the EEOC will now enter your settlement into the record, and they'll dismiss your claims as settled. However, any settlement agreement should have an enforcement provision that allows you the ability to file, let's say, a new action if that settlement agreement is breached. And conversely, that goes to the agency as well. If you as the complainant breach a term of the settlement agreement, then the agency has an opportunity to enforce the provisions of that settlement agreement. And I caution, sometimes when there is a breach and parties are notified of it, it's potentially that you could revert back to the position you were in prior to any settlement. So it's important to move forward with those the enforcement provisions if you do obtain a settlement. The next question is, how do you obtain all records of an investigation and provide responses? So, kind of twofold. One, that will be in the report of investigation. Any documentation provided by you or the agency to the investigator will be included in the report of investigation. Further, we talked about rebuttal. You'll have an opportunity to rebut anything that the agency states to the investigator, and you can include documentation to rebut that. Simple example is the agency official says ABC during their affidavit, but you have an email, you have a memorandum from that same management official that says XYZ. You can rebut that. And then going to what we talked about in the discovery phase. If you are in an EEOC hearing and you're at the discovery phase, you will have the opportunity to request interrogatories, documentation, and request for admissions. And conversely, you can provide that information as well because the agency is going to request it. So that's how you can get all the records in connection with your investigation. But it's important to know for discovery, you have to request it. You can't just rely on the agency to provide you these documentation. You have to request it in your discovery demands. And lastly, what is a mixed EEO complaint? A mixed EEO complaint is you are alleging a certain discriminatory act based on your race, age, religion, sex, so on and so forth. And it's mixed in the sense of that there is an adverse personnel action against you. So, say you receive a suspension, a demotion, something that affects your employment, the terms of your employment. Maybe it's a management-directed reassignment. It's an adverse employment action. Say it's a removal. And if you feel the removal is based on your age, sex, race, those protected bases, that's a mixed EEO complaint. So meaning it has aspects of the MSPB, Merit Systems Protection Board, with an adverse personnel action, but it's also discriminatory in nature. I feel I was removed because of my sex. I feel I was removed because of my race. So that is what a mixed EEO case is. I have a note here of another question. I can answer that. It says, in what circumstances is it better to request a final agency decision than request a hearing with the AJ? So in that case, I think, and this is once again my opinion, if you want to request a final agency decision, I would think that you want to be very, very, I guess, confident that you have concrete claims of discrimination and that the reasons the agency has provided are not legitimate. Because once again, and this is just my personal opinion, if you elect a final agency decision, you are requesting an agency official to determine that an agency employee discriminated against you. Now, once again, they are supposed to be, independent. They're not supposed to show favoritism, but, I think it's, that's just my opinion. It's no different than, I don't think an agency official is going to necessarily say that another agency official discriminated against someone unless it's blatant. So to answer the question, when is it, better to request a final agency decision? I think you need to be very, very confident in your claim. And another practical reason, I'll be honest with you, it could be a money issue. If you say, listen, I don't have the money to hire a lawyer, or I don't want to go through the aggravation of going through an EEOC hearing, if you elect a final agency decision, at least you'll get an outcome. At least you'll get some type of decision. So that would be another, although I wouldn't recommend it, that would be another instance where you would want to elect a FAD before you elect a hearing. A couple other questions, bear with me. Okay. Is the EEO and EEOC combined in the federal government? That is all, it's the same thing. The EEO is the Equal Employment Opportunity, and EEOC is an Equal Employment Opportunity Commission. Those are all one and the same. However, I should take that back. You can still file EEOC claims in connection with, say, a private employment matter. If you work for a private employer in, the District of Columbia, in Virginia, in New York, you can still file an EEOC claim, but there's state tribunals that deal with private employment matters in the EEOC. The next question is, what if that opportunity to rebut is not offered? Well, it needs to be. That is, you do have the opportunity to provide a rebuttal to the agencies or the responsible management officials. If the investigator doesn't provide you with that opportunity, that's certainly a procedural issue that I would discuss either down the road with an administrative judge, or I would raise it to the investigator, because you are allowed an opportunity to rebut that. So, another question, very good question. Obtaining an attorney is expensive. Can that be recovered if you win the case? Yes, it can. So, but you have to be the prevailing party. If you prevail all the way at a hearing, you are entitled to file a petition for your attorney's fees. Now, most likely, you will recover it, but sometimes a judge, you might recover all your attorney's fees or some. It depends on when or how many of your claims you receive a favorable decision on. Just for an example, if you had 4 claims and you received a decision that's only favorable for 2 of those claims, the judge may or may not provide you with all your attorney's fees. And of course, in any settlement, while an agency individual does not have any need to settle, they can still provide attorney's fees in a settlement agreement. Just looking at some other questions here. So the next question is, after my formal instance are accepted, should I tell my supervisor I have a formal EEO complaint that she is listed on? I don't think so, because if your supervisor is named in the complaint, they're going to be contacted either by someone within the agency or the investigator. So I don't think you necessarily, or I wouldn't, because you don't want to cause any kind of further potential conflict. However, I will add that if your supervisor is made aware of your EEO complaint and that they are a named individual, and then they somehow retaliate against you in any way, you can amend your complaint to include retaliation for including your supervisor on the complaint. But I don't think you need to inform your supervisor because they're going to be notified that they are a named individual in the complaint. Next question is, the agency contracts out for the ROI. The investigator is hired and paid by the agency. I've been made aware that many of the ROIs from the agency for other complaints have missed significant documents. Does this happen a lot? I mean, it's possible. Remember, if you, as the complainant, you have opportunity to provide all that documentation. So if you provide the information, documentation to investigator, and they don't include that, you can follow up with the investigator and say, hey, I sent you all these documents, they aren't included. If the agency doesn't provide certain documentation to the investigator, that is why I recommend discovery at the EEOC hearing stage, because all those documents can be requested. And if the agency further doesn't provide those documents, you can potentially request sanctions against them for not providing documentation, or maybe even adverse inference. If you feel there's a certain document out there that would essentially bolster your claim or support your claim, and the agency doesn't provide that document in discovery, then you can potentially get an adverse inference in your favor, meaning that the agency can't counteract any statement you made regarding that because they have not produced any documentation in connection with it. Okay, I think I got time for about 2 more questions here. Can an EEO claim be filed for denial of a reasonable accommodation? Yes, it can be, certainly. But that's important, because if you are denied the RA, reasonable accommodation, you want to do that. If it was, say, today, you got to make sure you initiate EEO contact within 45 days. You know, if you were denied a reasonable accommodation a year ago and there's no follow-up, you might be out of your time frame. So it's important that you file that within 45 days of the denial. Last one here. It says, can I take MSPB matters to the EEOC instead of the MSPB? It has to be a mixed complaint, and that's very specific. There's only certain matters that are handled at the MSPB and certain matters that are handled at the EEOC. You can't just say, you don't really have an option, I want to choose one or the other. The MSPB deals a lot with, like I said, adverse employment actions or decisions in connection with your retirement. But unless it's a mixed case, you can't really choose that avenue. You have to file the procedures as to where you can file. So you can't just choose one or the other. You have to file the proper processes and procedures. So with that being said, I want to thank everybody for their time today. It looks like our hour is up. I noticed on the slide we have contact information there. We've got our phone number. We've got our email. I would say that if you have any further questions, I strongly recommend you schedule a consultation with one of our attorneys. We can happily assist. And then also, if after that consultation, if you're looking for representation during the process, that's certainly something we could discuss. So I thank everybody for coming. I hope the information today provided was valuable, and looking forward to hearing from some of you guys in the future. Thank you, everyone.